Tuesday afternoon, 3 o'clock, you're going to be able to see me live in front of the Federalist Society talking about what happened that morning at 10 a.m., which is a huge deal. The United States Supreme Court is going to hear the United States versus Rahimi Second Amendment case all morning, starting at 10 a.m. Eastern Time this Tuesday. And at 3 o'clock, I will put a link to it down below. I will be speaking to judges, law clerks, lawyers, and others about this major case for the Federalist Society. You're not going to want to miss either. Let's talk all about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. All right, folks, so big deal, big deal. Here we go, folks. There's no hyperbole, exaggeration needed for the importance of what's about to happen this Tuesday morning at 10 a.m. in Washington, D.C., which is at the United States Supreme Court. The 9 justices are going to file into their room, and they're going to hear oral argument for probably somewhere between an hour and a half and 2 hours. We just don't know. In the United States versus Rahimi case, the case that Merrick Garland, Attorney General for Joe Biden, pushed to the front of the line to be the next Second Amendment case because Mr. Zaki Rahimi appears to be, on this court record at least, an odious character. This is the case that Merrick Garland wanted to get before the Supreme Court to try to undercut and destroy the protections afforded to you and to me under the Second Amendment's text and under the NYSERPA versus Bruin standard, which is really, of course, the Heller standard just kind of clarified a little bit by Bruin. This standard of Bruin has been so good for the Second Amendment that between the year of our Lord 2008 and 2022, the number of times we won between that period of the Heller decision and the Bruin decision was few and far between. Mostly because the lower courts, the inferior courts, as they're known under Article 3 of the U.S. Constitution, balanced away our rights using tiers of scrutiny, intermediate scrutiny, strict scrutiny, and balancing tests, all sorts of ways. Thank God to NYSERPA versus Bruin in 2022. Since then, we have won more cases in the last 18 months than we ever did in the 10 plus years between Heller and Bruin. So who wants to destroy that record? Who wants to destroy the methodology of interpreting the Second Amendment once and for all so it allows a blank check for government gun control law going forward? That is Joe Biden and Merrick Garland, who simply hate the fact that you and I have the right to keep and bear arms, and they want to destroy it, and they want to get the Supreme Court to help them do it. So, what's going to happen? Bottom line is, 10 a.m. Eastern Time, the oral argument will take place. I'm guessing it's going to go somewhere between an hour and a half to 2 hours. Hard to say in the new world, but that's what I suspect is going to be happening. As you know, the question presented to the U.S. Supreme Court is whether or not the federal gun control statute 18 U.S.C., stands for U.S. Code, by the way, 18 U.S.C. 922 G8, that says if you are a person subject to a domestic violence restraining order, you may not possess a firearm during the duration of that order. And that is the case even though the ex-spouse that, let's say, got it against you, or the person that got it against you lives in, let's say, Maine, and you live in Arizona, you cannot touch or possess a firearm in Arizona, even though the person who is the other side, if you will, the domestic violence restraining order, lives thousands of miles away from you. It doesn't matter. It deprives you and disarms you of all of your rights under the Second Amendment simply because of a civil process, civil proceeding. This is not criminal, civil process, civil proceeding, domestic violence restraining order. Now, that's the question presented, whether or not that's constitutional under the Second Amendment. You know what's going to happen. The U.S. Supreme Court is going to laser focus on the Bruin methodology, which is really the Heller methodology, reaffirmed and clarified a little bit in Bruin. And that is the text first, followed by historical analog laws second. So, what are we going to be looking for here? The first thing we're going to be looking for is questions from the court indicating where they may be coming out. It's just going to be a little tricky, and let me tell you why it's going to be tricky. There may be tension between the arguments associated with Zaki Rahimi himself and the Second Amendment movement in the following way. Zaki Rahimi appears to be an odious character. Now, that doesn't mean he's not entitled to constitutional rights or presumption of innocence. There have been plenty of odious characters that have given rise to very favorable constitutional rights, because remember, the whole purpose of the Constitution is to protect all of us, and we are all presumed innocent in all respects. Nevertheless, it is a fact based upon the record at least, that Mr. Rahimi, battered his girlfriend by hitting her head against the dashboard. He fired several shots over time at various people, although I don't think he ever hit anyone with what he did. And nevertheless, he looks to be kind of a problematic person, to say the least. Nevertheless, that doesn't mean he's not entitled to constitutional rights. So with that said, the first question I'm going to be wanting to see here is, will the Supreme Court treat the definition of the people appropriately? Specifically, remember the text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." So the question is Mr. Rahimi part of the people? Now, it seems to me the best argument, and I suspect it's the winning argument at the end of the day, will be that Mr. Rahimi, despite the allegations against him, is still going to be deemed part of the people for the purposes of the right of the people to keep and bear arms. Now, you may be asking me, why, Mark, do we care that Mr. Rahimi, in this case, is considered part of the people as defined, as referenced in the Second Amendment's text of the right of the people to keep and bear arms? The answer is, remember, at the textual level of the Second Amendment analysis, specifically how you interpret the Second Amendment with text first followed by historical analogs, at the textual level, the burden really lies with the person asserting the Second Amendment right. You see what I'm saying? At the textual level, you and I bear the burden to show that a modern-day gun control law is implicated by the text, that you and I have some sort of desire to carry a gun or use a gun or do something that's implicated by the text of the Second Amendment. That burden we want to make as easy as possible to satisfy, because once the textual burden is satisfied in a Second Amendment case, what happens next, as you know, is the burden shifts. The burden shifts from you and I, it shifts from Mr. Rahimi, it shifts from American citizens, and it shifts to the government. And that burden is on the government at that point forward to justify, through using historical analog laws going back to our founding in the year of our Lord 1791, to show that the modern gun control law is part of a long-standing tradition of regulating firearms in the United States. So with that said, the reason why we want to make sure that Mr. Rahimi falls within the definition of the text word, the people, is because if he does, the burden shifts to the government to justify 922G8 as a matter of historical tradition. What Merrick Garland is trying to do in this Rahimi case is he's trying to modify and shrink the definition of people in the text of the right of the people to keep and bear arms, because Merrick Garland wants to argue and is arguing that the only people that fall within the definition of the people in the Second Amendment are those Americans who are both law-abiding as he defines it and responsible as the left defines it. So therefore, if they want to say that someone who spits on the ground, who jaywalks, or speeds 5 miles per hour over the limit, or perhaps doesn't drive an electric vehicle or doesn't recycle properly, well, arguably, according to the left and the people that are the Joe Biden, Merrick Garland types, they would view you in those contexts as someone who's neither law-abiding nor responsible, and thus they want to argue at a textual level that you watching this video are not part of the people, and thus because you're not part of the people as defined by the Second Amendment, you watching this video because of you going 5 miles per hour to the speed limit or something along those lines, or you didn't get a license for your dog in the relevant town clerk's office, you are not part of the people. And the consequence of that is when you say out loud, the right of the people to keep and bear arms shall not be infringed, you will no longer benefit from that language, because under Merrick Garland's interpretation of the text of the meaning of the word people, you will not fall within the scope of the protections of the Second Amendment. That's why it's mission critical. We want the Supreme Court to say that Mr. Rahimi, regardless of his behavior, regardless of his past, regardless of whatever else that happens, that as a matter of text, he falls within the definition of the people. And that is the proper argument, I believe, because the words people appears in several other aspects of the Bill of Rights and the Constitution, including the First Amendment. And of course, it would be absurd to think that people that are part of the people, for the purposes of the Bill of Rights, one day on the next day somehow are not part of the people because they were convicted of a misdemeanor in some town somewhere. So I think that that argument by Merrick Garland is not going to prevail, but I am going to be looking to see whether or not they treat Mr. Rahimi as part of the people, either at the textual level or at the historical level. And the right answer is Mr. Rahimi is part of the people because all Americans, and perhaps even more than that, but certainly all American citizens are part of the people as a matter of text. And therefore, because this 922G8 gun control law implicates Mr. Rahimi's ability to keep and bear arms because it disarms him completely if he's subject to a domestic violence restraining order, it means that that implicates the text of the Second Amendment, thus shifting the burden to the government to come forth and justify 922G8. But Merrick Garland is trying to avoid the burden shifting to him in this case by arguing that Mr. Rahimi is simply not part of the textual definition of the people, and thus the burden never actually shifts to the Department of Justice. And that's where that game is getting played. A little inside baseball, but mission critical for us to pay attention to. So beyond that, I think assuming that we prevail on that, the issue is going to turn tremendously. And I think the bulk of this discussion we're going to see in this argument on Tuesday morning is going to be all about the history of the Second Amendment. It's going to be about the history, specifically about gun control regulations in the United States, and are there any that apply here? Now, I want to be very clear about a distinction. There are two conceptual types of laws, or genres of laws we should be thinking about, and I want you to be very precise about how to think about this Rahimi case. The Rahimi case deals with what I would call something that's preventative justice. Now, what exactly is preventative justice that derives from the word to prevent come from? The idea of preventative justice is that the government thinks that they think Mr. Rahimi, they think someone who's insane or psychopath, like perhaps that guy in Maine who engaged in that mass shooting a week or two ago. These people, by the virtue of the government, are somebody or something that is not anyone that can be trusted with a firearm. Specifically, these people, or they're people who are violent or incapable of handling firearms because they're mentally ill at a level that it makes them psychopathic or whatnot. And the notion of preventative justice is that before the person does something criminal, before the person does something violent and dangerous, they can be disarmed. The classic example of this, I would say, is people that are civilly committed into mental health institutions because they are deemed to be a danger to themselves, a violent physical danger to themselves, or a violent physical danger to someone else. And because of that, they are civilly committed in a mental health institution for the safety of themselves and for others. So that is the notion. So even if they've never committed a crime, you see, preventative justice concepts could allow people to be restrained or disarmed. That's the notion of preventative justice. This case of Rahimi is about preventative justice because at the time of the restraining order, the domestic violence restraining order that was entered, he had never been accused of a crime that I'm aware of. He had never been convicted of a crime that I'm aware of based on the record I saw. So the issue is simply by virtue of the fact that he's subject to a civil, not a criminal, a civil domestic restraining order. Is that enough to disarm him during the pendency of that order, where he's never committed a crime or anything along those lines? And that's really the question the court's going to be presented. This is a separate question than those presented by, let's say, the Brian Range versus United States case that we've talked about, or Brian Range versus Garland case, where Mr. Range was convicted of a crime. He was convicted of a crime 25 years ago. In that case, that's not preventative justice. What that is a criminal justice problem where someone committed a crime. In this case, at Brian Range, he pled guilty to a crime of, failing to disclose $500 in, lawn mowing income or whatever it was, and thus pled guilty to a crime subject that when he applied by lying, apparently when he applied for food stamps or something along those lines, and he was convicted of lying on that application, never served a day in prison, was never viewed to be dangerous to himself or anyone else or anything like that. And yet under 922G1, the so-called felon in possession statute, he was disarmed for life, and he sued saying that since he's not violent and there's no historical analog laws that would say someone who's committed a crime but is not violent, that you cannot disarm them under American historical laws. Basically, that's his argument. So again, that's a criminal justice problem. So Rahimi is a preventative justice problem. range is a criminal justice problem. They're separate because the range case involves someone who's been convicted of a crime after full-blown due process and had the opportunity to defend the case or fight against the case and was found guilty, either because he pleaded guilty or was found guilty by a judge or a jury. So those are the distinctions here. So the questions I'm going to look for out of the court is going to laser focus on preventative justice, specifically where's the historical analogs in American law to take guns away before they've committed a crime. That's where the laser focus is going to be by these justices on Tuesday morning at 10 a.m. And by the way, before I forget, I want to let you all know this. At 3 o'clock, I'm going to be doing a Federalist Society telephone Zoom call, if you will, for judges, law clerks, law students, others all across America, probably a lot of the members of the media. I will put a link to the information down below. So if you want to check it out, check out the information I post on X or down below. I believe you all can participate. I think you may have to register with the Federalist Society, but I think it's extremely easy to do. And then you can participate in the Zoom call, 3 o'clock Eastern time. But don't worry about it, because I will also talk about this oral argument on the Four Boxes Diner channel, in addition to the call for the Federalist Society, which will be Tuesday, 3 o'clock Eastern time. Okay, with that said, the other thing I'm going to be looking for very carefully during this oral argument is to the extent due process comes up. Now, here's the tricky little thing. Mr. Rahimi, technically speaking, arguably waived due process rights because he admitted to violent acts. He consented to the entry of the restraining order and signed off on it and swore to it by virtue of a notary. So arguably, he had due process rights, but he chose not to exercise them. It's no different than if you're driving a car and you're pulled over and the police officer asks you, can he look in your trunk? And you say, sure, officer, you can look in my trunk. Here's the keys. Check it all out. I consent. Well, you do have Fourth Amendment rights to be free from unreasonable searches and seizures and warrantless searches and seizures. Again, if you consent to the search of your car, yes, you have Fourth Amendment rights to be free from searches and unreasonable searches and seizures or warrantless searches and seizures. But if you consent to it, you consent to it. You basically waive all of that. So there's an interesting question here as to whether or not the court's going to be asking questions about, well, whether or not, yes, we understand there's due process concerns in all cases, but when you agree that you're violent, when you agree to give up your gun, which he did, and you consent to the entry of the domestic violence restraining order, why would we even talk about due process here? Because Mr. Rahimi waived that. So I'm going to be looking to see whether or not there's colloquy back and forth between the justices and the lawyers on whether or not due process is applicable here. And if so, what exactly is the due process protections to be afforded to someone like Mr. Rahimi before he loses his gun rights for it can be disarmed during the duration of a domestic violence restraining order. We will see a lot more of that. So, okay, folks, so bottom line is 10 a.m. is the Supreme Court oral argument. There's going to be a lot to see. I will probably be live tweeting it. So if you're on X, check it out. I will probably live tweet it out on X from 10 a.m. until it's over. And then again, I will likely get a video out for the Four Boxes Diner. And of course, I have that big call at 3 o'clock. I believe you're all invited to on Zoom through the Federalist Society, which is a big deal because a lot of important people in the media and beyond watch those things. So I'm honored to be able to be the person talking about the Second Amendment for the Federalist Society on this huge day, meaning the afternoon after the Supreme Court oral argument in Rahimi, the big Second Amendment case this term. And of course, we know that the range case is up for certiorari. So hopefully down the road, they grant cert to that case, but we won't know that for at least a month or more. So we'll see what happens. Okay. Hope you learned a little bit something here today. Big week this week for the Second Amendment. And if you haven't subscribed to this channel, please do so. And don't forget to share the video and with your friends. Don't forget to follow me on X at Four Boxes Diner. And we will see you again here soon at the Four Boxes Diner.
Orders up. Table 2A.